that in any event, General Masimola ought not to have been lumped together with these accused persons that are charged with fraud and corruption. Bear in mind that yesterday you accepted already that General Masimola is not complicit in fraud and corruption. Now,
till it is stopped, payments will continue. I understand this to read.
Advocate Johnson, apologies.
Sorry.
You and I know she has no power to invalidate a contract which on the face of it is valid. So when she says stop that contract, in what capacity? She's not a court.
Leave the country now. Those were the explosive words dominating online conversations after IDAC's Andrea Johnson came under intense questioning during a live hearing. As the pressure mounted, commissioners challenged her over key decisions and procedures, creating one of the most dramatic moments of the proceedings. Every answer raised new questions, and every exchange fueled even more debate. Supporters insisted Johnson was simply explaining her actions, while critics argued the hearing exposed serious concerns that deserve further investigation. Within minutes, clips from the hearing spread across social media, with thousands of viewers sharing their opinions on what they had just witnessed. The investigation is still ongoing, and no final conclusions have been reached. But one thing is certain: the spotlight is now firmly on Andrea Johnson, and many people are waiting to see what happens next. Could this hearing mark a major turning point, or is the biggest revelation still ahead? Stay tuned for more updates.
Till it is stopped, payments will continue. I understand this to read.
Advocate Johnson, apologies.
Sorry.
You and I know she has no power to invalidate a contract which on the face of it is valid. So when she says stop that contract, in what capacity? She's not a court.
She's not a court, no.
Yes.
But she is the risk. She's the head of risk and integrity, and she is saying to him that this contract has been unlawfully awarded, and we need to stop the contract. She says because of the time that has passed, the payments went out.
Sorry, this affidavit doesn't say when she told him to stop. So on this affidavit, at least we who are reading it now, and maybe you had other information that is not in the affidavit. On this affidavit, we don't know whether she told him in January, whether she told him on the 14th of May, and what the expenditure was by the time she told him, when it dawned on her that this contract should be terminated. So it's not what you're telling us now is not in the affidavit. So maybe tell us, where did you get it from that she told him to terminate? He did not. And in the intervening period after that, and the 15th of May, 50 million rand was spent, which would not have been spent had he acted when she told him. There's facts that are not contained in this affidavit, and they hold only if you got them in another way.
I understand. It's how I read the affidavit, that there is, in paragraph 2, there's an unlawful awarding of a tender to Medicare for a period of 3 years to the value of 360 million. She sets out that she suspects that
please allow me to stop you. You have accepted in your discussion with Ms. Sillo that the only mention of General Masimola is paragraph 8. That's the first time she says anything about him. That doesn't mean that she has not investigated and this is what she has found. She has done that. That's why she gives you the background story in this affidavit. And then at paragraph 38, she says something that now directs to General Masimola. And in fact, on a reading of this paragraph, the way she says it, she may not have intended to, but the way she says it is, I advised him to terminate, and he did terminate. That's what paragraph 8 tells you. You say, well, she told him earlier, he took his own time to terminate when she had told him earlier. And all I'm putting to you is, that which you are saying doesn't arise from this affidavit. On a sensible reading of this affidavit, in paragraph 8 in particular, or any paragraph in the affidavit, those facts that you are now speaking to are not here. Where did you get them from?
Commissioner Baloyi, I read paragraph 8 as her having advised him to terminate the contract. General Masimola ultimately terminated the contract. That he does. I read it from that ultimately there wasn't an immediate action. It was ultimately terminated and then prejudice was suffered. I don't take it from anywhere else, but just that reading.
But you see, to criticize him for not terminating immediately, you must know when was he informed.
I understand.
Logic dictates that.
It doesn't come out of here.
Yes, and that's a simple point I'm making, that on this paragraph in the whole affidavit, we don't know when she told him, right? So if we don't know when she told him, we are not in a position, and that you must accept, we are not in a position to say he delayed actioning her advice because she doesn't tell us when she informed him. We are not in a position to say because of his delay after she advised him, SAPS incurred 50 million rand expenditure, which it would not have incurred. It's not there aren't facts in this affidavit that make us able to conclude that therefore he delayed and he's liable, he failed to secure the monies or the assets of SAPS. You accept that?
I accept that.
All right, thank you.
Thank you, Commissioner. And I take it that it is General Matlow's affidavit that triggered the IDEC investigative powers and eventual prosecution of however many accused there are. Am I correct?
Correct.
You recall we started this conversation having considered what you stated, what you discussed with members of ad hoc. And there I referenced page 586 where Mr. Ngola told you that there was an allegation that IDEC is actively participating in a well-coordinated attack against General Mkhwanazi, General Masimola, and General Khumalo. Are you aware of it? You said you've heard of that allegation, but there is no truth to it. After this entire exercise we've gone through, do you still maintain that there is no truth or there is no basis to even believe such a narrative or an allegation?
Chair, I maintain that there was no, sorry, I don't have my file for the,
Ask me,
repeat the words.
The engagement at ad hoc?
Yes.
It's file 3, page 586.
Sorry, file 3. Sorry, Chair.
It's quite in order. Page 586.
586.
Midway the page. This is after, I guess it will be faster to find your own name, after you say that is correct. Then Mr. Ngola puts the question, there is an allegation. And then that's immediately followed by your response, and then you reference other criminal matters within the IDEC space. And you conclude, while we're at it, with the words, there is also no witch hunt against Lieutenant General Khumalo because there were no matters brought to IDEC prior to the referral by Mr. Adams. That's the part I'm reading. And I can very well perhaps appreciate the position you were in at the time you responded. Mine is slightly different. Do you still maintain the position?
That in any event, General Masimola ought not to have been lumped together with these accused persons that are charged with fraud and corruption. Bear in mind that yesterday you accepted already that General Masimola is not complicit in fraud and corruption. Now you accepted now in my engagement with you now that he ought not to have been lumped together with these people. Now that he has been, surely, and based on this principle, you must also accept that he would suffer the sort of prejudice that Trolip J.A. says an accused person should not be subjected to. And I cannot see any countervailing arguments to the effect that the state will suffer any prejudice if he is not lumped with these other accused persons. Do you agree with me?
And if, I think when it was flighted, section 157.
Can you just respond to
Yes,
what I suggested
yes.
to you now?
And I wanted to say that
yes.
because of, if you read 157,
Yes.
that becomes a bit more, is more appropriate then
Yes,
in
yes.
the circumstances and given the jurisprudence.
Yes, yes. But you basically agree with me. You've already agreed that he ought not to have been lumped together. Then I'm making another point, although related, which is that he will definitely be prejudiced in a trial that lumps him together with these other accused who are charged with fraud and corruption, both of which he is not charged with. Do you accept that?
I accept that.
Now, a question that goes to what I've always emphasized, I think I did so even on the first day, which is that we are not trying to suggest that General Masimola has committed no offenses, no. But, and this is something that Commissioner Baloyi's question touched on, we want to know why this was done. Why was this done? You've agreed very easily. You know these principles. You apply these sections all the time. Why was this done? Why was Commissioner Masimola lumped with these people, charged with fraud and corruption when he is not? When he is charged with the statutory offenses provided for in the PFMA, why was he lumped with these people? At face value, it seems to me that this must have been done to embarrass him, to taint him, and to make the public, or to cause the public to see him as also being complicit in fraud and corruption. People are not going to, ordinary members of the public are not going to analyze this. He stands there, people charged with corruption, fraud. He stands there with them. And most of the noise when the case is talked about is going to be about the fraud and corruption. People are not going to delineate and say, but not Masimola. Do you see what I mean? So this was done, I suggest to you, to embarrass him, to taint him, and to make him look as if he too has committed fraud and corruption. That was calculated, I suggest to you. What do you say?
Chair, I understand. I gave the contention that I did, that the prosecutors put him in one matter because there's the serious complex fraud corruption, and it would be one matter when they lead the evidence with the PFMA. I'm giving you the explanation that I have for the prosecution. I accept that this matter, he should be separated, but at no stage, Chair, was there an intention to embarrass. I can understand the optics thereof, but at no stage in the charging of Commissioner Masimola was there an intention that he be embarrassed.
Were you involved with the decision to join him as a co-accused in this, with the other accused? Were you involved with that decision?
Yes, the prosecutors take the decision. When we were briefed, we agreed that he's charged only for the PFMA.
No, my question is, someone made the decision that he will be accused number, whatever number, on that gallery,
The
right?
prosecutors.
My question is, before that decision or when that decision was made, were you party to that decision when it was made?
That he would be added at the end.
That he's added as a co-accused with the other, however number, whatever number they are.
Based on the contentions that I've given, which was given at the time, yes, ma'am.
You see, what's problematic with this is the fact that you have already agreed that in terms of the sections, he ought not to have been joined at all. He ought not to have been. Now, what makes this situation worse is the fact that he is being joined down the line. Not that it would have been correct if he had been joined at the same time the charges were brought. No, that would still have been legally wrong in terms of 155 and 156, and you've agreed to that. Now, but what makes it worse here, he is joined down the line. Surely, your minds should have focused on, we already have charges against all of these people. We are charging them with fraud and corruption. Now we want to put in an additional person. Is it in accordance with the law to join him in terms of 155 and 156? Surely your mind should have been focused on that. It's not as if a mistake happened, we just lumped these people together instantaneously, it sort of just happened. But anyway, I say, things like these cannot just happen. So if it's wrong in law, it would have been wrong, even if he was lumped right at the beginning. But now, the point I'm making is, you lump those together, they are all charged with fraud and corruption. It makes sense to lump them together in terms of 155 and 156. Now with him down the line, how is it that your minds are not specifically or particularly focused on, but must we lump him together with them? Surely your minds should have been so focused. Otherwise, I do not understand why that was not the case.
I understand you, Chair.
Did you? I may be repeating Commissioner Baloyi's question, but I will repeat it for emphasis. Did you focus your own mind on this issue at all?
Yes, there was a discussion on whether he was going to be charged separately or whether he was going to be joined. I give the argument and can take it no further than what was given.
After that discussion, or during that discussion, did you specifically focus on which basis under 155 or 156 we can join him? Did you focus your minds on that?
Not me specifically.
When you said there was a discussion, did that discussion not involve you?
The discussion involved with 157. Should he be charged separately or should he be charged jointly? The prosecution
you
team...
can't, sorry. You can't separate 157. It must relate to 155 and 156 as well. You cannot separate 155 because you charge people in the same proceedings if they have committed the same offense.
That discussion happens and then we go to we then go to Commissioner Masimola.
So you were part of that discussion, you say?
With the prosecutors. Yes, when they did the briefing.
Yes.
Yes, there was an engagement with the prosecutors.
Yes. And you concluded that there was a legal basis in terms of the Criminal Procedure Act to join him in these proceedings. And if you say so, and you must have reached that decision. So if you say you found a legal basis, what was that legal basis? And in terms of which section exactly?
So in terms of the legal basis that we found, Chair, it was the argument was used as the at the bottom of 156 of them being charged together because the evidence at the trial of the one would be used and may be admissible at the trial of the other person.
Is evidence about the commission of corruption, the commission of fraud, admissible as against General Masimola? If so, for what purpose?
Not admissible against him, but to lead that evidence to
No,
then
Joy, but-
show it.
Continue. Please continue.
Okay. It was in having this one trial, you lead the evidence of the fraud, the corruption, all of those irregularities. And it's all the same evidence that will then talk to the PFMA evidence, because you would have to lead, if you take him and put him separately, you would still have to lead that same evidence to get to him, to show what was it, what was the irregularities and or the unlawfulness that was happening, who all was involved, and what were his duties. So instead of duplicating that evidence, they put them all in one matter. We would lead that evidence. It will then in turn show that that serious complex corruption, etc., that happened, had it been stopped when it should have been stopped, would not have led to this. Not doing it together, Chair, as was argued, would mean we'd have to do two separate matters. That was the discussion at the time.
Was that correct, insofar as he is concerned? Remember, you just said, in response to my last question, you just said, evidence of the commission of corruption and the commission of fraud is not admissible as against General Masimola. And if you look at 156, that is what a prosecutor must tell the court as to why the prosecutor is joining accused persons together. So if you accept, as you did in response to my last question, that evidence of fraud and corruption is not admissible as against General Masimola, you do not get off the starting blocks under 156. Do you agree?
I agree.
So he
I was
was
giving you the discussions that we had.
which were wrong ultimately in terms of the decision that was reached. Do you accept?
I'll accept that.
Thank you.
Thank you, Chair and Commissioners. Let's stay with the Major General Matlo's referral affidavit. And that's file 9, page 3519. And based on your, I think, our engagement yesterday with the commissioners on matters relating to General Masimola's arrest, this is our starting point, correct? General Matlo's affidavit is what eventually triggered the arrest, the eventual arrest and prosecution of General Masimola.
On a point of correction, I did indicate earlier that she submitted the Section 27
Yes.
together with a preliminary report.
Which preliminary report has not been provided to us. And I want to see how you reach that conclusion when on the wording, the very wording of the affidavit, there is no suggestion that anything is attached thereto.
I checked with the team, this 27. Did it have anything else? Because that is the question. In the absence of anything else, Council, which was the conversations we were having yesterday,
Yes.
then a lot of things could not have happened. And I was informed that there was a preliminary report that was attached.
It doesn't particularly help the commission because only you and whoever it is you spoke to know of an existence of some preliminary report. The document that triggers this entire process does not even suggest it's submitting any further documentation, preliminary or otherwise. If you go to paragraph 5 of that affidavit, it speaks of a comprehensive internal report is currently being compiled. It doesn't say in the interim here is a preliminary report. So on a logical interpretation of paragraph 5,